Thanks, Joe. Mr. Fisher?
Regarding the issue of legal fees, I have a couple of different perspectives. The money that's been spent has been spent. I mean, that's a simple reality. I think there are some legitimate issues or concerns from my perspective as to whether the money was spent judiciously. We have, to be sure, some fights that I personally think are good fights. I think the town of Brookfield fight is a good fight. I'm concerned about the amount of money we spent. Big picture, I'm concerned. I mean, this past year we used 7 attorneys. The town of Waukesha, I think there was a lot of duplication of effort. I think a lot of inefficiency, which drives up the cost. I'm particularly concerned about the way we retain attorneys to provide legal services for the town. The snow plowing lawsuit, which was initiated before I took a seat on this board, ended up costing us $297,500 in a settlement fee, and we spent over $100,000 on that in legal fees. I think, leaving even aside the issue of whether that was smart to file a lawsuit with which I disagree, a do-over on that or reconsideration would say retain someone on a contingency basis if we're going to get involved in a fight like that. All of the retainages we do for all these attorneys are hourly based work. Read our ordinances. There are specific provisions in there that include different methods by which to engage for legal services, including a salary, basically annual or monthly salary. That's the way historically, to my understanding, the town had budgeted and contracted for legal services. Now, to be sure, that would cover general matters. When we get involved in special situations such as litigation, that would not reasonably be anticipated be included in that way. But I would say moving forward, our town would be very, very well served to seriously consider engaging legal services on a salary basis, because at this point in time it's just hourly based, and I think there's an awful lot of unnecessary time that's spent that runs up these tremendous prices for legal expenses. So that's something I really think we need to take a look at in the future. Thank you.
Why don't you share with us, Mr. Fisher, which of those expenses you feel shouldn't have been spent?
Okay,
You've made some pretty broad
all right, well,
statements.
I will give an example then, if you want to know that. On the Walgreens and Aldi's matter, last spring that was addressed here without autopsying what happened. Basically, Supervisor Bansky went to 2 attorneys at O'Neill, Cannon, Holman, Young, and Lang, who I think we've never even worked for, and ran up a over $6,000 bill without any kind of authorization. We didn't get anything that was worth a dime for doing that. So that's a concern that I've got. Unauthorized, unnecessary expense, and that ends up being a big bunch of money. So there's an example for you.
That's a terrific example, and I'm really glad you brought up that particular item.
I appreciate it. Thanks for the opportunity to do so.
The reason that happened is because you, Mr. Fisher, would not accept the recommendation of our town attorney, Hector De La Mora, when he indicated that we needed to provide a document regarding a certified survey map that was reaching 90 days in submission to us. You argued that point. You achieved your goal that night into not having that particular document taken care of. And it's true, Mr. Bansky and I were very, very concerned about that particular matter. So we did some investigation of our own, the 2 of us, into our ordinances. And our ordinances found that we did indeed need to provide, the ordinance and statutes did reveal that we absolutely needed to provide notice to the particular petitioner on the CSM. And what happens is if it's submitted and it's not acted upon in some way within 90 days, it becomes automatically approved. Automatically approved. And that was what Mr. De La Mora was trying to protect us from. And we had worked with the firm of Cannon O'Neill historically. And we were able to make sure that we weren't in a significant problem there. And you're right, it shouldn't have happened that way. And I'm sorry that it had to happen that way, but the town needs to be protected. And when people continue to not take advice from our council, it creates more duplication of effort. And some of that is the responsibility of those who seem to argue each and every point in this rather than just taking the advice of council.
Yeah, respond.
I don't think we need to have a debate, but is that's
I'll give a brief
your statement of fact?
response. It was a botched up mess that you and Supervisor Vansky and Attorney De La Mora botched up. And it cost $6,000 that nobody authorized to try to fix it, and it didn't get fixed. So that's my statement.
Well, it did get fixed because the CSM was not approved. We were able to send out the document that needed to be sent out. It just cost us $6,000 more than it should have. So that was an expense that should not have happened. That did, and part of that is because we need to accept the recommendations of the professionals that we hire, and have respect for the professionals that we hire because they're all capable people, and ultimately they're looking out to protect the town taxpayers. So the statements that you made about duplication of services, I have no idea where you're coming from on that. I think our legal team has been excellent. You have been, as has everybody here at the board, been aware and approved any and all legal expenses that the town has spent, other than perhaps the $6,000. In any retaining of attorneys has also taken place through resolution. And so all of us were involved in retaining an attorney, in deciding who was going to represent us for any matter. And to say that we've done that poorly, I guess then would reflect on all of us because we were all involved in many of those closed sessions where we worked on that strategy and determined the best course of action. Now, it is true that we've worked with more than one attorney. We've had a tremendous challenge since we came into office in July of 2010. The initial matter that we had before us was the Lathers wells, the Lathers property and the CSM for that, and the wells that were actually put in on that land and were actually functional. And permits had been issued, and that was a real concern for many of us because we knew it meant that our water supply could be affected. We hired a specialist, Dean Lang from the firm of O'Neill Cannon, and we found him through doing research. He had done work in a similar matter in the Brookfield area, had argued with the DNR and had argued before the Supreme Court, and won, in fact, at the Wisconsin Supreme Court level for his client. And that suit that he won for that client has an impact on us. And we had that specialist who also worked with us and got that accomplished. And won that case. Those wells are now capped and the permits were pulled. So the fact is we have hired specialists. Yes, they're more expensive, but the overall cost for that was basically minimal given what we achieved for a very, very reasonable cost. And I think you certainly, I liken it to doctors. I mean, you either want to get a specialist or you don't. I think we have looked at who we felt would be a specialist in any area. Attorney De La Mora is a wonderful service provider in that regard because he will be very proactive. He is very proactive with us when he feels as though there's no reason for him and his staff to start from scratch to learn an issue, but to hire somebody who's already had experience in a particular situation so that they can hit the ground running, and we as townspeople have the benefit of that knowledge base that someone else has gotten through other clients. I mean, I think we all want to work with people who, you know, you don't want the doctor who's having that surgery on you the first time. You want to have the guy or the gal who's done it 100 times or 1,000 times. And that's the policy that we've made the decision to do as well. Same thing happened in the town of Brookfield. Yes, we had more than one person. Attorney De La Mora's firm is involved. Attorney Dean Lang's firm is involved in the litigation side of it because that's his specialty. And then we have a gentleman, Mr. Zeineman, out of Washington State. You might say, well, that's pretty weird. Why do we have somebody working from so far away? But that was somebody that was found by Doug Hofer, an associate of Mr. De La Mora, by doing research on who had the best background and knowledge base on the particular situation with the town of Brookfield and their incorporation petition. And the person that Mr. Hofer found, yes, now resides in Washington, but actually worked at the Department of Administration and was part of the team that wrote the last denial here in the state for the town of Brookfield a number of years ago. And he's married and his wife got a job in Washington State. He practices law there, but wrote a very involved article about some of these very issues. And because he was a specialist, we interviewed him, and we felt that he was best to do that work. So that recommendation came from Attorney De La Mora and his firm. We've been very pleased with his work. He's very efficient because he knows the law inside and out. He's written the documents, he's reviewed these particular incorporation proceedings, and so he can provide us, and he knows the area and the information. So we did make the decision proactively to use him. That was a recommendation from our attorney. So we're using people that have the knowledge base and can provide the best information to us. And I feel very, very comfortable with what we've done. There's always ways to learn more, but all of our staff people that we've utilized are very good and have all been approved by all of us.
Jamie, do you have the figure as to what we spent for Attorney Lang on the Lathers property?
Yeah. All right, it is mixed because we have used both, we've used Lang on both issues. So the total amount, we have both the City of Waukesha and we have the Lathers property issue, so I'm going to call that out. I think the last time I looked it was about $30,000. On the entire City of Waukesha so far, from start to finish, so that means from 2011 to the bills that we paid in 2013, we paid $92,000 for City of Waukesha related issues. And I believe it's about $30,000 that's specifically related to the DNR and the Lathers property.
Everything involved with the city, though, was pertaining to the Lathers property, correct?
No, because we have the water service area that we were dealing with. So we have significant dollars related to the water service area, and keep in mind that there was also a lawsuit that was started by you and your group before we got in on suing the city. So, you know, for those permits and for those wells, so we settled that. That's been ongoing, and that's...
There was not a lawsuit started with my group per se, okay, prior to the changeover. That's what prompted the recall.
No, there was actually a suit filed before the recall election in early July, and that started some of the costs related to that and why we had costs already in 2010 and 2011. But the everything related to the lawsuit related to the DNR and to the city, and this includes a lot of technical assistance. This includes the technical assistance from our consultant, Bruce Baker, who we hired. Bruce Baker was retired in 2011, I believe it was, from the DNR. He was originally working with the City of Waukesha as the DNR chief in DNR offices on their application. So he was very familiar. He also was one of the people that was involved in writing the compact document that's going to be used to review this application when it comes on. So we were able to hire him as a consultant. I just called him out of the blue one day, and he was enjoying his retirement and asked if he would consider being a consultant for us because he was so intimately involved in this. And so we have his work as part of this cost as well.
And what were we trying to accomplish when we hired Lang pertaining to the Lathers property in the City of Waukesha?
To close out the wells that were already in place on the Lathers site.
There were test wells on the Lathers site.
Yes.
They were not functioning wells for water for the City of Waukesha at that point.
Yeah, well, I was waving your hand because...
Whenever you're ready, you know.
I guess I'm not sure what
They
the
were
question
not.
is.
What is the outcome of the Lathers property at this point?
Those wells are capped and the permits were pulled.
City of Waukesha now owns that property though, correct?
That's correct, but they have no permits and they have to start the process over. And in the meantime, because Dean Lang won his case on the Lake Beulah matter, the doctrine has changed and there's a higher level of requirement for those permits to be issued in the future.
That would be the letter we sent to the DNR requesting they contact the town if somebody comes in for a permit. The response from the DNR was pretty simple, wasn't it?
Colleen.
I guess I'm not sure where we're going with
That
this.
was a waste of money.
What, it was a waste of
It was a
money,
waste
sir?
of money.
It was a waste of money to have the permits pulled from those wells and no longer have the wells on that property.
Yeah, there's still wells there, just not pumping out of them yet.
They're capped, they have no permits to pump, they have to start from scratch. So it's as if those wells do not exist. So that's the suit that was won. That was a very important suit because at the time that we came in, those permits had already been issued and those wells were put in. And that was recognized by the previous administration as well, and that's why they started the lawsuit at that time in early July 2010. And we certainly took it from there and replaced the attorney that was working on it at the time because he didn't have a specialty in that and he supported us in that change and then hired Attorney Lang. But this really is questions with the audience, so maybe we should get back to that. Questions from the audience? Well, gee.
Darn right. Just getting silly.
Okay.
You people, come on. You missed out last time, you missed my talk. Yeah, I know, maybe you watched it. So, you're almost all unanimous all the time. It isn't fair to come here now and pick apart your own decisions when you've been making them unanimously. You're wasting your time and you're wasting our time. Stop doing it. I went out and counted every motion last year. You missed it, but you can look it up. And almost all of them were unanimous. I think there were 9. It's online. Mr. German made the motion to oppose the incorporation of Brookfield. This was on December 27th of 11. Then, following that up in February, he made another motion to adopt a resolution reaffirming and approving. On February 7th, Bansky made the motion and German seconded it to second the Jacobson settlement. All of these passed unanimously. Which legal battle did you not vote for? Which one did you not vote to settle? You all voted to do them all. And to come in here now and say that they were botched or they were a waste of time is wasting our time. Now get down to business.